She is an associated researcher with the Humboldt-Institut for Internet and Society in Berlin. Amélie, please.
I'm gonna need the
You can just
notices.
click on the mouse or
Yeah.
that
Well,
works.
Isn't it? How do you do
What's that?
the presentation mode with the?
F5?
Yeah, but I need the.
I don't do PowerPoint, so I don't know.
No, I'm just gonna take my. Sorry. No, that's fine. I just need the notes and that's all. Sorry for the delay.
היא לא יכולה לשים את זה שהיא רוצה לראות הערות.
The notes. Good morning, everyone. Thanks for being here. I would like to briefly present my paper on upload filters that I handed into this conference. So in my paper, I looked not only at the technology of upload filters itself, but also as upload filters as a possible threat for freedom of expression. It's also the way in which AI or filters are deployed in content moderation, and I challenged the classical definition of censorship in German constitutional law and in the ECHR jurisprudence with regards to the fact that censorship in a classical definition has always to be state-driven, whereas the deployment of upload filters and content moderation mostly done by private actors. So I would like to start with this quote by Zeynep Tufekci. She said that when anyone can broadcast live or post their thoughts to a social network, it would seem that censorship ought to be impossible. And this should be the golden age of free speech. So my question is, do we live in this golden age of free speech, or where are we heading at? I think that social media platforms do enable new forms of expression and information, and are therefore a progress to democracy and society. However, the way online communication is moderated raises questions, and they do challenge our classical concepts that we have, especially in constitutional law, and the way that we interpret those concepts. So AI can be used in for the purpose of content moderation, but we have to look very closely at the way it is being implemented and the way we want to implement it in the future, and especially looking at the progress of the past year. I have found that even the companies using upload filters or AI in the content moderation come to the conclusion that the technology is not ready yet to be deployed in a way that would also respect human rights. So, as most of you probably know, we use algorithms to select and display the most relevant content, and artificial intelligence to optimize the user experience on social media platforms. And what is really important in the way that we use... That's, yeah. The mic, okay. Okay, thanks to that. what is really important when we look at this whole selection and filtering process is that in our idea of freedom of expression and information, we incorporate opinion formation, and that process of opinion formation needs to be free in order to have a free own opinion. And so as soon as we have some technology looking or imposing some view or retaining some points, we're maybe no longer free in that sense. So the upload filters, as they're being used at the moment, have the function of filtering out unwanted and possibly unlawful content. It recognizes the content, it's being hashed, it is then can be deleted and at least be recognized the next time the hash is being used or recognized. So what social media platforms do is that they use those filters to filter all of the user-generated content that is being uploaded on the platforms, and if a violation is being discovered, the content will not be published at all. What we usually refer to as a two-step procedure, as a notice and take down or a notice and stay down procedure. And here, when we look at those filters, there's a first human in the loop that is programming the filters, but then there is no additional reviewer looking at it, only if there's an appeal to that decision, which might not even happen in those cases where the user is not aware of what's been happening or informed on the grounds of the decision. So upload filters are mainly used in against copyright infringements and also against terror propaganda. Here you see again what I meant that user-generated content is being filtered, and that's something that I, from what I saw from what I know in German constitutional law, is a prior restraint that is forbidden by constitution. So the effect of upload filters corresponds to exactly the definition of prior restraint that we have in this classic interpretation. Which means that if this upload filter was to be used by a public authority, it would already be forbidden. There would be no way of using it. And the question is, when we look at social media platforms using it, we cannot apply the formal definition of censorship. But what if the prior restraint is being used as by private parties, but on behalf of state institutions? And can we expand the notion of censorship to actors that have a significant influence on intellectual life, regardless whether they're public or private actors? So the case I've been looking at closely is the EU database of hashes, which is a countermeasure against terror propaganda, as a case used for this paper. And what I can tell from my research is that this is typically a situation where a private actor has been forced by a code of conduct, so by a soft law instrument, to use proactive measures such as upload filters in order to first find and then delete suspicious content and especially terror propaganda. This database of hashes was introduced by the EU Commission in March 2017, so it's pretty recent, on the grounds of a code of conduct from May 2016. So the first results have shown that the first assessment that most unwanted content is being deleted before going online. So it's exactly the case where the content is already being blocked before it even has been published, and that most of the deleted videos are those or many that have been uploaded for the first time. So it's not a filter that's filtering a re-upload of something that has already been hashed or perceived as unlawful or unwanted. It's already within the first attempt to publish it. The report from YouTube says that 98% of their videos today is being deleted because of their relation to violent extremism, which is a very vague definition, and it was marked by machine learning algorithms. And the reports have also shown that the technology is not fit for purpose yet, so that's what I mentioned in the beginning. It's not yet capable of identifying criminal behavior in the field of hate speech, such as libel and defamation, and upload filters still lack the ability to understand content in context or to identify other exceptions, such as satire, for example, which could be an option here as well. So this is what I've been mentioning earlier, that the two elements combined of a handshake between the public authority and social media, private actors, but also the fact that the technology is not yet fully developed, brings us to the problem of what is with this handshake between state, private actors, what implication does it have for the user, therefore also the citizen. I think that this brings us to a classical question of collateral censorship, which has already been examined in the past, but here it's really something that has been invisible to most users, and in this database of hashes, for example, we had initially 4 IT companies, so Microsoft, Facebook, YouTube, and Twitter. Now there's up to 13 companies. It's not only the companies that have access to it, but also Europol, Interpol. So you have not only in the grounds on which it has been built, it's very mixed between public and private, but also on the access to the content that is being collected. It's also a mixed access, because not only the companies share the data with other companies in order to share knowledge, it's also there's also an access from a public authority. So the question is, which path can we take in this way? To me, we should, the main point, or the main priority at the moment, is to make this invisible handshake more visible, to get out of an alliance that is not visible and therefore cannot be object of any legal procedure coming from a citizen. And the main goal is here to clarify the legal basis for the use of such technology, and to make the whole process more democratic. There is possibly end at the light of the tunnel, as we say in German. I don't know if we say that in English. But there's a new regulation coming on EU level, at least. The EU Commission has published the first proposal end of September 2018, exactly on that matter. So that would at least bring the past regulation out of the shadow and into the light, and therefore maybe make it more accessible. Thank you.
Thank you very much, Amélie, and thank you for keeping time, which is very rare in academia. Our next speaker is Dr. Moran Yemini. who is a senior fellow here at CCLP and a litigation partner at the law firm of Herzog, Fuchs and Neyman, and a visiting fellow at Yale ISP. He has published articles in the field of law, communication, and philosophy, which have been frequently cited in academic articles as well as by U.S. federal courts. His research interests consist of various aspects of the intersection of technology, political theory, and law, including the relationship between technology and morality, the theory of internet governance, constitutional rights in the digital age, and online freedom of expression. He holds an LLB magna cum laude from Tel Aviv University and LLM from NYU, and most importantly, a PhD here from this university in law and technology. In addition to his degrees in law, Moran's academic background also includes an undergraduate degree BA magna cum laude in communication and a graduate degree MA magna cum laude as well in political science, both from Tel Aviv University. Moran's going to talk about Mill's mistake, truth, democracy, technology, and the inner tensions of free speech theory. Moran.
Hi, good morning. Thank you very much for having me, and thank you for setting this great event. I always love to come to Haifa to speak because on the way from Tel Aviv to Haifa, I turned from an old lawyer to a young scholar. So, and obviously, it's better to be young than old. I want to start with referring you to a research that I got yesterday in one of the WhatsApp groups that I am a member of. PubMed is the professional search tool for medical research, and if any of you has ever seen a PubMed page, then this looks at first glance as entirely genuine. Of course, unless the authors of this article, Cristiano Ronaldo, Lionel Messi, Wayne Rooney, Mesut Ozil, and Sergio Aguero, lead a parallel life as researchers in the field of checking the effects of shawarma on, then this article is totally fake. Now, to be a bit more serious about that, this is a kind of message that was created originally in order for the receiver to detect as false after a few minutes or a few seconds. But then I thought that it would actually be very easy for someone or something to create a similar message which I would not be able to detect as false. Perhaps also my wife, who's a physician, would not be able to detect as false. Now, this presentation will not be about fake news because fake news is not something new. The United States went to war based on fake news much before they were called fake news, and it did so at least twice. Fake news or fake intelligence. What I do want to argue, however, is that digital technologies in which AI play an increasing role, do require us to reevaluate traditional beliefs and conceptions about free speech, including false speech. My emphasis here in this presentation will be on how technology affects or should affect our understanding of the purposes of free speech and how to promote them, if they are still relevant. So let's start with the basics, which is the main justifications of free speech as identified by classical free speech theory. One is the argument from truth, which holds that freedom of speech assists in advancing knowledge and discovering truth. The second is the argument from liberal democracy, which holds that freedom of speech is essential to collective self-governance and to the operation of a democratic form of government. And the third is the argument from personal autonomy, which holds that freedom of speech reflects respect for individuals' autonomy and rationality and promotes individual self-fulfillment. The first and perhaps most familiar justification is the argument from truth. That is also the basis for the marketplace model, the marketplace of ideas metaphor. And then we had a time in which the democratic rationale was dominant during the 20th century against the background of the mass media model of information production. And since the advent of the internet, there has been some in which they actually enhance fake news because they treat fake news and legitimate news equally. So while producing fake news is much cheaper than producing legitimate news. The third aspect is an increased ability to personalize messages, in which also AI plays a key role. Big data tools facilitate audience targeting and personalization to an unprecedented extent. This means that those with an economic or a political interest in the dissemination of false news are better equipped than in the past to deliver their content to those that they most desire to reach. So if we take, for example, Justice Brandeis's terms, then the magnitude of the evil that truth needs to cope with is much bigger, much larger. The filter bubble, echo chamber phenomenon, that work to deflect news sources and content that do not correspond with users' established content, preferences, and political orientation. There is a diminished ability to distinguish between legitimate and false messages, among other things because of problems of information overload. And there is an enhanced speed at which false messages can be disseminated, also also by humans, but also, and to an even greater extent, by bots. For much of the same, this relates to the filter bubble. In one of the presentations that in one of the lectures that I heard once, this was used in order to show that there isn't really a difference between the past and the present, because when people waited or went on the train, now they look at their cell phones, and previously they all looked at newspapers. They didn't speak to each other anyway. But of course, there is a very big difference between these two scenarios, because here everyone is looking at the same newspaper. So the mediator between people and reality is different than in the picture in which everyone is focused on his own cell phone, and we don't know, and arguably also gets information from different sources. For much of the same reasons that I mentioned earlier with regard to truth, technology also invokes a reevaluation of the notion that more speech means more democracy. Okay, thanks. The network form of communication doesn't necessarily promote democratic values, and wide access to means of communication doesn't in and of itself promote public discourse. And now we are evidenced with growing demands towards social platforms, for example, to restrict speech in the name of democracy, rather than to promote speech or to provide access. Social platforms are expected to filter and to moderate speech, and actually to restrict it. So perhaps Alexander Michael Jones was right all along. From the standpoint of the argument from democracy, what is essential is not that everyone shall speak, but that everything worth saying shall be said. Which means that our speech environment should be regulated. Now, this brings us to a further complexity, which is that even if, assuming we overcome the problems of who decides what is worth saying, acceptable restrictions from the standpoint of democracy might not be acceptable from the perspective of the autonomy rationale. The argument from democracy may not think that it is essential for everyone to speak, but the argument from autonomy is all about letting everyone speak. So there is a direct clash or a potential increasing tension between these two rationales. One possible way to cope with the challenges to democracy on the one hand and the need to respect individual autonomy on the other hand is to differentiate between human and non-human speech, to protect the speech of autonomous beings and not to protect the speech of non-autonomous beings. And for the sake of argument, I will not go into the question of whether the speech of an algorithm is actually reflects the speech of the person that wrote the algorithm. Okay? I'm putting that aside. It's a complex question in itself. So this is one solution, but it's not an ideal solution because both from the perspective of democracy and from the perspective of autonomy, because from the democratic perspective, AI speech may also contribute to public knowledge. What we are concerned about is not AI speech per se, it's deceptive AI speech. And also from the perspective of autonomy, restricting AI speech may undermine individual autonomy from the perspective of an individual listener for the process of meaning making. A more nuanced solution is protecting AI speech to the extent that such speech carries value for the overall system of free expression and remains consistent with individuals' autonomy-based free speech rights. Now, to put this into context, I will give an example. In one of the cases in the US, it was concluded that Baidu, the Chinese search engine, has the First Amendment right to exclude results in its results page in the United States regarding democracy in China. Now, if you look at this decision in light of the justifications of free speech, then it's providing a free speech right with no normative justifications, no normative basis, because it doesn't promote the discovery of truth. It certainly doesn't promote democracy, and it's inconsistent with autonomy. So it receives protection only because it's speech. It looks like something that someone says. Okay. But the last point that I want to make, and I'll make it briefly, is that these solutions as well may be short-lived because technological developments in strong AI are likely or may require us to reassess the argument from autonomy as well. And this may be the most fundamental level at which technology may affect traditional thought about free speech. Strong AI may require reassessment of the relevancy and applicability of the autonomy justification to an environment in which it may no longer be possible to draw clear lines between human and non-human communication. And in a future in which we interact with such strong AI, we might be forced to redefine our concept of a person if we want to equalize between, to look at an AI in the same way that we look at human individuals, or autonomy if we proceed from the keynote speech that we had this morning, because we may decide that what we think of as autonomy today is not what autonomy will mean in 10, 20, or 50 years. And with that, with this promising and optimistic view, I leave you.
Thank you, Moran. And now we go straight to our third and final speaker of this panel. So Thiago Dias Oliva from Law School of the University of Sao Paulo. He is a PhD student in international law at the University of Sao Paulo and head of research on freedom of expression at Internet Lab, an independent research center based in Sao Paulo, Brazil. Thiago holds a master's degree in human rights 2015 from the same university, having been granted a scholarship from the Sao Paulo Research Foundation and the German Academic Exchange Service. He is the author of the book Sexual Minorities and the Limits of Free Speech 2015, and he's going to talk about content removal technologies, new challenges to freedom of expression. Thiago, please.
Good morning, everyone. I'll start talking very quickly about the institution I work at because it was where I developed research on the subject I'm going to present here. Internet Lab is an independent research center based in São Paulo, Brazil. We aim to foster academic debate on around issues involving law and technology, especially internet policy. And among our different areas of research, we have one focused on freedom of expression. I'm the head of this area, and this is where I'm currently studying the subject I'm going to talk about. So let's start talking about it. The paper I wrote is on content removal technologies and risks to freedom of expression and access to information. So I'm going to start with the context. As we all know, the digital environment has enabled new ways of communicating and sharing content. Big platforms like Facebook or YouTube, Twitter, enable users to publish and disseminate all sorts of content. And also, which means that it increased the possibility for people to express themselves online and getting heard. And also increase the amount of information we have at our disposal online, which is great. But this also led to dissemination of harmful or problematic content, such as non-consensual intimate images, hate speech, fake news, copyright violations, terrorist propaganda, just to name a few. And these are challenges we need to face right now. So in this context, platforms have been pushed by public authorities and also by public opinion in many countries to increase their moderation efforts. This move has led these companies to adjust their terms and conditions of service, design more sophisticated frameworks for dealing with undesirable content, and hiring more people to work as moderators. And due to the huge amount of work that is required for moderating, they have also started developing artificial intelligence to work with automation decision-making regarding content moderation. So for the paper, I developed research on the state of art of the technologies regarding different kinds of content and how the platforms are implementing these technologies to cope with their moderation efforts. The idea was to assess the risks these technologies pose to free speech and access to information, and think about possible ways of reducing those risks, and how academics and also digital rights organizations are approaching the issue and making recommendations for the platforms. So I'm going to start with copyright violation, because this is probably the type of content which we have more papers work on, more information on it. And maybe because due to economic reasons, copyright violations seem to be one of the major concerns of internet platforms. Section 512 of the Digital Millennial Copyright Act in the United States sets forth safe harbor protections only to online services who act very quickly in the removal of allegedly infringing content upon the notification of copyright owners. That means that intermediaries, internet platforms, will pay the bill in case they do not remove this kind of content very quickly. Copyright owners started then, in this context, using robots, to present huge amounts of takedown requests, what caused major intermediaries to develop and implement technology designed to automatically filter supposedly infringing content. Very recently, for example, Google reported being notified about 880 million URLs that allegedly infringed copyright in 2017 alone. So it's a huge amount of work to be done regarding moderation of copyright violation. Content ID, which is a technology developed by Google, which was launched by YouTube in 2007, it identifies and takes down infringing content. The system works by receiving reference audio and audiovisual files from copyright owners, it analyzes uploaded material and contrasts it with samples of the files uploaded by right holders. In case users attempt to upload files that match the ones provided by the copyright owners, the material may be blocked before it even becoming available on YouTube. It identifies inexact matches, consequently enabling a more comprehensive removal. Very recently, YouTube, it was like a couple of weeks ago, maybe last week, I'm not sure, I don't remember right now. YouTube reported that Content ID is able to detect the changing of a video's aspect ratio, flipping images horizontally, changes in audio speed, as well as performances and remixes. Despite being one of the most sophisticated technology of the sort in the market, Content ID have reportedly failed to recognize fair use cases and have erroneously allowed non-copyright owners to act as such in the absence of a reliable method for assessing copyright ownership. As a result, Content ID may end up compelling users to obtain a license when, in fact, they should be free to use content wrongly reported as copyright material in their own creations. But let's talk about other kinds of content. So internet platforms are employing hash matching technologies, algorithms to curb the dissemination of child pornography and non-consensual intimate images. This technology, the way it's being implemented, it only identifies exact matches of the uploaded file and not modified versions of it. So they also receive the content, and they do not allow the upload of material that matches these files. Content perceived as extremist is also being taken out by hash matching technologies, as Amélie talked about earlier. In 2016, Facebook, Twitter, Google, and Microsoft announced a shared database of hashes for removing this kind of content. Whenever one of these companies detects and removes what it considers extremist content, which is defined according to the terms of use of that platform, the others are able to use the hash to find and remove the same file from their own platforms. In addition to technology dealing with audiovisual content, internet platforms are developing technology for handling text-based harmful speech. Current technologies use language processing and sentiment assessment in the attempt to detect harmful text without relying on a set of banned words or phrases. So even though this technology has evolved a great deal over the past years, the accuracy of commercially available tools reportedly remains around 70 to 80%. There is a takedown non-harmful content 1 in every 4 or 5 times. In recently published papers, 2 groups of researchers mentioned that minor changes in sentences and in their structure, what includes inserting spaces between words or typos between words, can deceive perspective. Google's artificial intelligence, diminishing a lot the perceived toxicity of harmful speech. This Google's perspective, for example, it gives you a level of toxicity when you insert words and phrases, and it seems that it's not that difficult to fool the technology. There was another study, for example, that showed that if you insert love in the middle of the sentences, despite the sentence being harmful in some way, it also perceives it as less toxic. So meaning is highly context-based, and depending, for instance, on audience, place of communication, speaker, and tone, things that are not yet that technology cannot is not properly able to assess in the present moment. So without proper safeguards, these tools may cause overbroad censorship and bias enforcement of laws and platform terms of service. So in short, state of our technology for handling text-based harmful speech seems not to be very efficient right now in detecting this kind of content without signaling too many false positives, and therefore posing risks for freedom of expression and access to information, since algorithms may automatically remove non-harmful speech. And hash matching technologies similarly lack the ability to properly assess context in the moment we are right now. This context blindness that seems to be the rule for most of the commercially available artificial intelligence tools may be tolerable in policing child pornography and non-consensual intimate images, content that may never be justifiably shared, but it might compromise the legality assessment that these algorithms are able to perform in connection with other kinds of content, such as those labeled as extremist, for instance. And we had a case of, for example, content being removed, a whole channel being removed from YouTube because it was found to violate this guideline of extremist content. But it was a channel of a human rights organization that was reporting war crimes in Syria. And this context blindness seems to apply towards platforms forbid as well. So Facebook, for instance, has banned the words dyke, fag, and tranny, and has enforced this ban in a way that reportedly overlooked attempts from the LGBTQ community to reclaim these words as means for self-expression on the platform. So it is important to point out that these illegitimate removals do not only infringe the right of individuals to express themselves by posting content, but also deprive the public as a whole of consuming wrongfully limited speech, thus damaging access to information. Content shared by public people, like politicians, artists, influencers, and also by representatives of interest groups, for instance, LGBTQ, Black, and feminist activists, may play an important role in bringing attention to pressing issues and help communities to articulate around it. But as soon as these shared materials are blocked or removed, this whole process is damaged. So I'm going to present some recommendations regarding having this on mind. Digital rights organizations and academic experts have expressed great concern regarding the current policies of platforms for policing for policing content, and they have come up with these principles, because since we cannot say that platforms should not employ artificial intelligence for dealing with moderation, since it could harm innovation, and we may get to a point where these tools are actually more efficient in removing only objectable content. So we do not want to hinder this evolution, this development, but we should then think about procedural measures we can take in order to diminish the risks that these technologies pose right now for free speech and access to information. So I'm just going to outline these three principles before ending my presentation. The first one, companies should publish the number of posts removed and accounts permanently or temporarily suspended to violation of their content guideline. So they should provide more information to be more transparent about why the content is being taken down. The companies should also publish numbers on it to also be more transparent about how they are dealing with by policing content, and they should also allow users to appeal from content removals. And for instance, we just had very recently, Facebook has declared that it's going to actually develop an independent body for reviewing appeal requests from content removal. So yeah, this is I guess this kind of approach is also already being having some effect on the platforms. And well, I think my time is up. Yeah, well, this is what I wanted to say for now. Thank you for your time.
Thank you, Thiago. So just before I'll open it up for Q&A, just some general questions that I wanted to ask, and I'll just start broadly. We talked a lot about transparency. You talked a lot about transparency and oversight, and this is things, I mean, oversight less, but you talked a lot about transparency. There's a thing that always matter. And you always, Thiago, you gave some concrete examples on what should companies publish, the amount of takedowns or something which doesn't comply with the policy, the numbers. But we've seen that. I mean, we've been there. So you can go to transparency reports by Google, say, and see how they removed allegedly content for copyright infringement or the right to be forgotten, and you'll see the numbers like you presented, 2 million, 80 million, etc. What can you really learn from that? And how will that type of transparency really aid us to decide or to aid free speech to that extent? And to add to that question, I would say that how much does this discussion is really different from the discussions we had 20 years ago? I know AI is a bit more sophisticated to a great extent, and that applies not only to you, I think to all of you in general. What is the real difference with AI that we should really rethink the technology that we use, the legal mechanism that we use, or perhaps we should adapt by how we conceive human rights. Maybe human rights are those that might need to be reshifted into different directions.
Thank you for the question. I think I'm going to maybe start with the second one. So why is it different right now? I think that what is different right now is the context and how these platforms became so important for people to communicate and also to access information. So I don't have numbers right now with me, but I know that for sure in Brazil, like Facebook is where people gather information right now. So it's more about the scale and of importance that these platforms have and the effect they have on what's being discussed and on what people know. So I think it's more about the role they play right now than 20 years ago. Maybe we could have the same discussion, but the problem was less serious, I would say. This is how I see it at least. And about transparency, transparency was only one of the three principles. I actually think that the other two ones that there are more procedural recommendations in the sense that they provide us with some tools to fight how can I say that, unjust removals, legitimate removals. So being informed on why the content was removed, because many users don't even know that the content was removed, and also understanding why it was removed, which guideline was violating, to be able to properly appeal from this decision. It will be more interesting if it is an independent review body, of course, and this is also in the subset of the principles. I just outlined like the general principle, but there are more specific to it. And I think the transparency, it's something, it's not new, but I think that's something we have always to push for, because it's more about adding some pressure on the platforms for them to know that they are being watched and that they have this importance in the ecosystem of information, and that we are all aware of what's going on. So I think it's more, in the case of transparency, it's more trying to shape the way the platforms behave and how they approach the problem.
Moran, Amélie, do you want to also contribute?
With regard to your second question, I think that what I tried to point out was that there is at least a quantitative difference between what happens now and what happened what took place 20 years ago that has substantive implications. And there are also potential direct substantive implications, for example, in figuring out what AI speech is and what kind of protection, if any, it deserves. I agree with you that we may need to rethink traditional conceptions of human rights, but if we accept that the ultimate unit of moral reasoning is a person, then many questions that did not raise 20 years ago in the existence of conflicts are raised now and did not raise then, and in the way that conflicts should be adjudicated. Anyone else?
Yes, please. I would maybe put it a bit differently. I think what frightens me is that when I did research for my paper, I saw that Oliva was working on that 20 years ago. No, really. And then, no, but it's like, why are these questions still there? And I think we have to be aware that if these are like problems, for example, what I look at is like state action or private action questions, that they're still here, whereas the technology has evolved. So it's not only automation, it's not only big data, it is something that is still unknown. We still don't really know what's going to happen with that. So bearing in mind that we still have trouble to figure out stuff from the past, and then we need to wind it with something that we're not really sure about yet. That, I think, is what makes the situation so special.
So I will not further abuse my powers as moderator, so we'll start with questions. Milo, please.
So I'd like to jump in on the issue that you just started to discuss, that is what is different, right? And so I think that at least in two presentations you were talking about the notice and takedown. Notice and takedown was something that developed in the 90s. We thought that legal people would sit there and write a notice, and someone else would read the notice and then remove the content. Whereas today we talk about hashtags, right? And we talk about AI and machine learning that would actually identify it. We heard maybe before you even think about what you want to post, right? And so that is a difference. And just to make it more concrete, Amélie, you started your presentation by saying that this is, about, the view that this is a golden age of free speech because we cannot censorize live stream. But there it is. There is a new paper just released, right, of a group of people that developed this system that actually can identify infringing live streams. And this is a huge business, right, because we have live stream of sports games, right? And the problem with live streaming is that you don't have a regional to match with the infringing platform. So how do you identify live streaming? You go to the chat. You go to the places where people talk about the videos. And so you know that the video is coming. You analyze the chats, right? You know the video is coming, and then you can remove it before it is even coming up, in the air. But there you have it, we're gonna have, this system running on our chat, right? And analyzing what we talk about, compromising our privacy, our free speech. Do we want to do that? This is a dilemma we didn't have. This is a new tool creating a whole new, different range of values, compromising, creating new balances that have to be drawn, in between these values. And I think that is, where it's a different ballgame. It's not the same, right? And so, but this is just a thought about what you were saying, and I have two quick questions, okay? So one is, Amélie, could you talk a little bit more about the database of hashtags? I think that this is something that is personally I'm less familiar with, how it was created, what is the legal authority under which it is working. There is a lot of government and corporate collaboration, especially in the context of terrorist propaganda, and I think that would be interesting to hear about. And a question to, I think this goes relevant to Moran and Thiago, and I think the question here is, do we care about the systems, or do we care about who is doing that? Who is making the decisions? I mean, I listen to Moran and I'm like asking myself, is this a cultural war that, we don't like that speech, it is online because there are all these speakers. I mean, maybe they didn't like the fact that the newspapers were deciding about what was wild. But maybe this is just a cultural war, since we're on the losing side as academia and media, and maybe that's too bad. And maybe this is a speech that should be protected, or do we have any better answers to that? And on the, I think on the human automated thing, I would also suggest that bots may have a role. We want to say this is not speech, it's bots, but behind the bots are people, and they are not heard. And if they have a legitimate interest in being heard, maybe we should think about it as a digital megaphone that make their voice heard.
Yes, so I'll maybe start with the database of hashes. So in light of the increased terror propaganda, especially via YouTube and other video platforms, the EU Commission has created in 2015 the EU Internet Forum, which was kind of a working group from companies and the European Commission to face the problem of terror propaganda online. Following that, in May 2016, they the IT companies I mentioned earlier, so Facebook, Twitter, Microsoft, and YouTube, has signed this code of conduct that was against terrorist speech, and in following that, in this code of conduct they agreed to filter or to use intelligent measures to filter content looking for terrorist propaganda. And in March 2017, they founded the database of hashes, which is basically a common database of all the content that's being uploaded to the mentioned platforms, hashed and then made available to all participants, which includes Europol and other criminal enforcement agencies.
Is it available to the public?
No.
And any oversight of this? I mean, maybe there is, maybe the name of the Prime Minister there, right? I mean, does anyone look? Any independent authority?
Well, at least in Germany, we regard the Staatsanwaltschaft, the penal enforcement agency, as independent and also acting upon any suspicion. However, I don't know how do they look into this database and how they look at it. But that's the story.
Regarding the question of do we care about systems or about people, I come from a point of view in which we care about people, but things that are happening make me wonder whether I was wrong, or whether systems are actually the things that is the thing that matters. So I myself am conflicted on this issue, and it's very much, I think, correlates with ethical standpoints on whether you take a more consequential utilitarian point of view or a deontological point of view, whether you emphasize the liberty aspect of political theories, theories of justice, or the equality aspect, how do you reconcile them? But I do think that it is very hard to justify limiting the speech of real people, even if it's false speech. On the other hand, we do that all the time with other kinds of speech that receive less protection than others, commercial speech, defamatory speech. So it's not unheard of that we would treat certain kinds of speech differently than others. It would require courts to make normative decisions, which I was maybe a bit unfair with courts when during the presentation, because courts are not just lazy in not getting into the normative questions. They want to be neutral about them. So they prefer, if something looks like speech, then they will protect it. We don't want to go into the question whether this specific speech promotes justifications or not, but I think that we may not have a choice. If we really think that democracy, I'm putting the truth rationale aside, that if we think that the autonomy and democracy rationales are important, then we may not have a choice but to take a different stand on, for example, false speech and develop a different doctrine with it.
Thank you very much. Very interesting panel. One, I think you are introducing very intriguing concepts and really very interesting to think about whether AI speech should enjoy a different protection or a different level of speech rights associated with it. I want to challenge this with two issues. First of all, would you agree that instead of enjoying different level of protection, it might be something like notification requirements? Because there's like laws now being passed after like the Ashley Madison issue, that it would realize that bots created fictitious feminist speech in order to incite male users to use the platform. So there are laws being passed that if it's an automated AI speech, you have to notify, I'm an AI, or I'm automatically generated this speech. So the way to do it is not that they had to reduce freedom of speech right, but some kind of notification requirements, sometimes even disclosure requirements about what's my sources or how did I draw this speech. With a human, normally we do not impose such notification requirements. Second question is, would you consider, I think that in your presentation, it was very clear that you're a big believer that the internet primarily created more fake news, fake speech, non-worldwide speech. You're more sided towards this direction. And also with the AI speech, you kind of assume that an AI speech is very likely to be something that go against some of the, I think, values that we adhere to. Autonomy, personal autonomy, search for truth. But would you agree that there are many cases that AI could actually be used for the reverse and might even enjoy higher value in terms of speech, free speech, that kind of like correcting errors, checking facts, getting sources that normally no editor would take and present them. So there's actually a big positive value to AI speech. Would you also be able to consider that in the level of protection that you awarded?
Okay, so just try to be brief with your answers because we have a few more questions.
Well, regarding the second question, I think I said it perhaps briefly during the presentation, but AI speech may definitely have value. It may promote democratic values. It may promote truth discovery. So, but the question is whether it does that, and if we come to the conclusion that it doesn't do that, and it doesn't promote the rationales of free speech, then we can consider and should consider not presenting. or giving it less of a protection, assuming that the autonomy rationale is not relevant to them. Okay? And it may be relevant if we take another step and attribute the autonomy to the creator of the AI, the human creator of the algorithm. And again, these are complex questions which I think in many times they are correlated with or intertwined with the issue of corporate speech, which most of the AI speech is actually corporate speech. That's, I think, in my mind, should deserve less protection than individual speech. So I agree that AI speech may have value, and it's not, it shouldn't deserve less protection categorically because it is AI speech. Okay? If it promotes certain values that promotes the system of free expression, then I accept that they can that AI can hold free speech rights like corporations do to a limited extent, or to a certain extent. Now, with regard to the first question, I think that the transparency can be part of the. It's a kind of a transparency solution. What you're suggesting. So it can be part of the solution. I'm personally quite a small believer in transparency as an only remedy. Transparency without sanctions and without the ability to of the receiver to analyze the information that it receives. Maybe that's relevant in the case of transparency that says that I'm a bot. But transparency without sanctions, I think, is problematic. But that can be part of the solution.
Thank you. Fascinating panel. One question on like your reflections. One is whether we have to think about what human rights guarantees actually mean in a different way now. And if I get it right, then we started when we talk about human rights that they are a yardstick to assess individual government actions or state actions. And now we use them to assess socio-technical systems. And we want to say that if it's designed in this way, then we have a problem with human rights or with freedom of speech specifically. What are the implications actually? Do we have to think more in terms of procedural guarantees, for example, like transparency and things like that? I agree that transparency as such is not a magic one, but you need to have it embedded into some structure. But in general, as an example for procedural guarantees, that we have to start to think in lines of state-of-the-art clauses. So we say, as long as these kind of machine learning is not capable of understanding this and that, then that means in terms of human rights that you cannot apply system A to a problem B and things like that. Do you think that is something that we should be more aware of when thinking about freedom of speech and human rights? And does your research support that, or would you say that's not the real idea, or is your reflection on that?
Well, definitely the context is quite different. But the way I see it, we have this doctrine of applying human rights between also private parties. Like the state must ensure that private entities and also people in general that have much power in society must also comply with some obligations in correlation with this power. So the way I see it, it's another context, but I believe that these guarantees still apply. And what I think that we can do in this context is, as you mentioned, and as I mentioned during my presentation, is we should not try to try to hinder the innovation and the development of these tools. because they already are useful despite of these errors they made, and we might get to a point where they are way more sophisticated and that the risks are way lower for user speech and access to information. But what we can do, I think, about procedural guarantees, then this is what I think, and this is I think what digital organizations are also talking about. So thinking in procedural ways to diminish these risks. Like those two I briefly talked about, like having ensuring that people know what was taken down and why, so they could appeal, they could have opportunity to present more information on the content that was taken down and why the content should stay up. So there are procedural guarantees in this line that may help to diminish the risks we have without hindering innovation and without saying that platforms should not should not employ this technology. So yeah, I think that we are in different contexts, but so we have to think differently about the approach we have, but we have to still have this framework on mind. This is how I see it.
Yes, I mostly agree, and I would add that to me the procedural guarantees is maybe the only set of rules that we could possibly transfer from old speech to new speech or to the new structures. That's exactly what I thought when Niva mentioned the example of censoring live streams. Maybe the only thing that will help us to answer that type of question is proportionality. How big is the risk if we don't look at if we don't check on private chats? Is it something that is how high is the risk and how can we balance it here? So that would be the type of procedural guarantee that I would also think of something that we can take along.
We're running a little bit short of time, so I'm going to pick up 3 questions from people who asked before. So Yafit, 1 question each, not 3 each. Yafit, Elite, and Ryan just ask, and then they'll try to answer it in the 5 minutes. Yeah.
It's more of a comment than a question. First, for Facebook, for live blocking, I did some work on blocking around the copyright, and I gave a talk a year ago, and I was surprised to find out that Facebook is actually blocking live speech, and they do have the technology to do that. So it's not some science fiction, it's not like the first research paper. Facebook is already applying that. YouTube also to some extent, but it seems from my research a year ago that Facebook is very advanced on this, specifically in copyright. I don't know about censoring other kind of speeches, but in copyright specifically, they say if you are sitting in a theater and you live stream the movie that you're watching, we're going to block it in the course of the first minute. So we are talking about live blocking. And also I want to say, when we talk about censorship, it's important to include not only removal or complete removal, but also censorship through obscurity, which will sometimes not be just pushing. If we think about search engines, which most of the platforms are these kind of queue technologies, right? If you push someone down in the search results, and we saw that with trademark infringement. So Google used to do that when there were websites that engaged in trademark infringement. After a few strikes, they just pushed them down the list. So they didn't take them out of the search results, but they just pushed them so way to the back so people would not find them. So obscurity is something to consider also in the context of not only blocking, but promoting speech, right? So when you put someone up in the queue, you're pushing down the kind of speech you're not interested in. So, yeah.
Open source claimed before that if there are enough eyeballs, all platforms are relevant. And the same is relevant to Wikipedia. In my opinion, the difference that we challenge today is the way that data is spread and the way it reaches us. And here the size does matter. So the more news in one direction or news evolved in one direction, gain more credibility. And while thinking that, maybe creates a new bias to strong groups, not the citizens that can just use the bot and amplify his speech. But is it really free speech now? Do we just protect free speech, or do we protect speech of the big companies that have the connection to the platforms? What we do? Do we want to protect the speech of the small citizens?
This question is mainly for Moran, but I think it could be interesting for other speakers as well. We've got a tendency to feel like we live in the middle of history, that we've never gone through these hyper-attack war. Can you hear me?
Speak up a little bit.
I say we've got a tendency to feel sometimes that we live in the middle of history right now. We've never gone through one of these cycles before. And you make a really persuasive argument that the rise of AI is really challenging the fundamental nature of what is freedom of speech, what is speech itself. And my question is, to what extent is this really a completely new paradigm that requires us to reevaluate these notions? To what extent is this part of a cycle that we've seen in the past with the rise of the printing press, and television, and online message boards, and social media? During each one of these epochs, people have come forward and said this is minimizing the importance of speech, concentrating the channels of speech, and we've managed to overcome that and incorporate it into the paradigms of what is freedom of speech. Now, it may be that this is something completely new, that this is a level beyond this, that AI is taking it from humans to a different level, and we actually do need to reevaluate. But perhaps to keep it in proportion, we can say that this is just a new challenge in a line of challenges that we've successfully managed as legal scholars to incorporate into the traditional understandings.
Okay, so a very brief response, please, for whoever wants to respond.
Very brief response for a very big question. Well, I'm not arguing that technology changes everything, but it does change things. For example, it does create challenges with regard to what speech, what should be considered speech, something that is very important, for example, in American doctrine. As I wrote elsewhere, I also think that it transforms our understanding of freedom of speech. In my mind, it, for example, incorporates into the notion of freedom the capacity to speak, which in 20th century political theory was something that was regarded as a question of social justice. It wasn't part of freedom. Freedom was equated with liberty. And on the other hand, there are challenges to liberty. So I think that there's kind of a trade-off between capacity and liberty in the 21st century, in a way that is kind of has kind of turned the problem that the 20th century problem on its head. The problem in the 20th century was lack of capacity and formal liberty, and I think that the problem now is quite opposite. So there is capacity, but there are certain dimensions in which liberty is infringed. So that is the best, I think, answer that I can give in a minute.
I would just like to briefly react to Yefit. Exactly, I've known from live blocking questions only regarding copyright until now, mainly in music, but that still leaves us with a massive and suspicion-independent filtering. And regarding the censorship through obscurity, it's very interesting because we are still thinking about the right to be republished if you've been deleted or blocked just because it's unwanted and not illegal. But does this right to be republished also come with the right to be visible? Right. Because what does it give you if you're republished but not visible? Nothing. So that's, yeah, indeed.
Just quick comments on the question of whether we're talking about people's free speech or corporate free speech. I think that the thing is that nowadays it's quite difficult to differentiate between the two, since most of the people are online and people are talking online, and they rely on these platforms to communicate and to share content. So I really think that we should focus on people, but sometimes since we rely on these platforms to be connected to each other, and sometimes it's difficult to differentiate what is if we are protecting in fact the company when we are trying to protect user speech. So yeah, it's quite tricky, I would say. I have no answer.
Please join me in thanking our wonderful speakers for this panel. And we have a short break now. We convene here in 15 minutes for the keynote.